In this video, I will be explaining the concept of the hypothetical person skilled in the art, also often referred to as the skilled addressee, and how this concept applies to Australian patent law. The person skilled in the art is a hypothetical legal construct, a tool of analysis which is used as a standard or reference for the court to evaluate various elements of patent applications, such as novelty and inventive step, which we would cover later on during this video. So, why does the court require this fictitious test? As Justice Kirby explained, judges themselves could not be expert in all of the fields of science and technology involved. They were, therefore, invariably reliant upon expert evidence in that particular field. That expert here would be the person skilled in the art. In other words, when assessing a patent, the court will put itself in the shoes of a person skilled in the art to evaluate the elements or contentious issues of the patent in question. For example, for patents involving medical procedures, the person skilled in the art may be a surgeon carrying out the procedure, or a researcher who develops a particular method. Then, what are the qualities of the person skilled in the art? Traditionally, the person skilled in the art has been described as a non-inventive person who possesses ordinary skill, who works in the art or science of the invention. However, depending on the invention in question, the person may be required to be skilled in more than one art. Therefore, in highly technical fields such as pharmaceutical patents, the person skilled in the art may actually refer to a whole team of researchers rather than one individual. Case law has further demonstrated that the person is to be aware of what was common general knowledge in the art at the relevant date. This means that the person should be presumed to have access to everything in the state of the art, which may include any research documents or methods and facilities for experimentation, which together may comprise part of the common general knowledge. Inventiveness is a key criterion for patent applications. Generally speaking, anything that is not obvious to a person skilled in the art is said to be non-inventive. It is important to know that although the person is to be non-inventive, many members of the court have recognized that this may create problems in certain fields such as biotechnology, where inventiveness is a prerequisite skill. Although this conundrum has not been directly answered by Australian courts, it seems unlikely that courts would apply this non-inventive element strictly or literally. The person skilled in the art applies to Australian patent law in 5 main areas: construction, novelty, inventive step, usefulness, and sufficiency. In terms of construction, it is important to understand that patents are not required to be constructed for the average person to understand. Instead, it is addressed towards a person skilled in the art in the particular field of the patent in question. Novelty is a key criterion of patent validity under Section 7 and 18 of the Patent Act. Any invention that has been previously known to the public would not be patentable. The test applied by the court here is whether the person skilled in the art, having reference to the prior art base and common general knowledge in the field at the priority date, could foresee such an invention without exercising inventiveness. The next element of patent validity is inventive step. Here, the key question is that whether the invention would have been obvious to a person skilled in the art. This is examined by asking whether that person, having common general knowledge in the field, whilst being aware of the problem to which the patent was directed, would be led to discover the claimed invention. It is important to note that the standard for obviousness is quite low. Even a very small amount of inventiveness is sufficient to support an inventive step. The element of usefulness is quite straightforward. For an invention to be patentable, it must demonstrate usefulness to a person skilled in art who is intending to make utility of the invention. Note that an invention does not have to be an improvement to be useful, it could simply provide an alternative method to current technology. Finally, Section 40 of the Patent Act provides that a patent must sufficiently disclose the invention in a manner so that a person skilled in the art may be able to produce something without new inventions, additions, or prolonged study. A patent may be revoked if it was not sufficiently disclosed. So, in summary, just remember the person skilled in the art is a hypothetical legal construct. It is a tool of analysis which guides the courts in setting and determining parameters for evaluative judgments regarding different areas of patent law.